right, thank you. Mr. Perkins is being brought in. Before the court is Ms. Lindsay Simmons, who actually authored today's pre-sentence investigation report. She is from the Department of Corrections. She's here today for sentencing on a charge of failure to pay child support. And there are actually 2 counts. Plea was entered and accepted on March 20th of this year. Ms. Williams, any amendments, corrections, or objections to the contents of this report?
Your Honor, I always like to update the amount of arrears currently owed. It's $27,176.58. If that was not, and then I have no further corrections or deletions to the report. Thank you.
Thank you very much, Ms. Freer-Ventos. Any questions?
Thank you, Your Honor. I have reviewed that report to my client. He has a copy. He appears to have dropped it. But we've reviewed that. He has no questions, comments, or corrections at this point. Do not have any either, Your Honor.
All right, let's go ahead and turn to allocution then.
From the people, Your Honor.
I'm sorry.
Okay.
You didn't see it. I was gesturing to Ms. Freer-Ventos. Sometimes I mix it up. I don't really care who goes first. Let's go ahead and go with Ms. Freer-Ventos if she's still standing.
One moment, Your Honor. I want to consult with my client on one thing very quickly. I thank you, Your Honor. As for allocution, we would respectfully request, Your Honor, that the court order only time served here with some sort of period of probation. As Ms. Williams pointed out, the arrears is going up. My client is older. He can't work and he can't pay his arrears when he's in the jail. And the goal of these is to get payment. In light of the snow factors, again, rehabilitation, deterrence, and rehabilitation, deterrence, punishment, and protection of society. Keeping Mr. Perkins in jail doesn't really do much to serve those factors, especially considering he has already sat a significant jail term, which is ample to deter future missed payments. He would respectfully request that the court allow him an opportunity to get out, start working, and start making payments. And he has learned from this experience that he needs to stay in contact with the court. He needs to stay on top of things, even if he is out of state. That is not going to stop this court from making sure that the arrears are collected. And we respectfully request he be given that opportunity. Thank you.
All right, Ms. Williams.
Yes, Your Honor. I have reviewed the pre-sentence investigation report. I would ask that you adopt the recommendations of the 3-year probation and all state and crime victims' fees assessed in the report. In terms of defense counsel's requests, I guess her bond argument, we typically do ask for 25%. She is correct in stating if he continues to be incarcerated, obviously he can't work. Sounds like he may not be anyway, but there isn't a great payment history here. However, if the court finds good cause to release on a personal recognizance bond today, the people will not object. Thank you.
All right, Mr. Perkins, is there anything you wish to say? Well, these cases are all about trying to get people to pay for child support, but in this particular instance, the kids are already grown, already gone. Now, I did not know this. I think when I took the plea, I know one of the kids' children. She went to high school with my daughter, and graduated from high school, but I mean, I know her because she and my daughter were friends once upon a time. And that's the youngest of the children here. And you really have not worked at all. Very much, at least. Your work history is basically minimal to zero. Been able to spend money on marijuana, cocaine, and alcohol. That's disappointing. Apparently those things are a lot more important to you than your children. You're currently on probation for an offense out of Texas. You had a little bit of a criminal history. It's not excessive, but none of this really resulted in any significant prison commitment. So, and this statement here just is offensive. The 4 words in this statement, which are the ones that I circled, are, why did you do it? Just didn't want to. Bad. Why is that bad, Mr. Perkins? Why does that sound bad? Yeah. You cared about the other stuff, the alcohol, the marijuana, cocaine. Apparently was more important to you than your children. I don't really hold out any hope that you're going to pay any of that $27,176.58. Feel bad for the children, including the 2 that I do not know. And I haven't seen the youngest one in, I don't know, couple years or so, at least 3 or 4 years. I don't find that to be any cause for recusal, because I know a lot of people in this town, and I've seen a lot of kids, whether it's sporting events and dancing programs with my children. So this just seems to be silly to put you on probation when there's no real way you're going to pay, even though you're only 47 years of age. Well, guess I'll give it a shot. Put you on probation for 36 months and adopt the terms and conditions on CFJ 145 pages 2 and 3. Well, I don't think they are going to work. I'm supposed to start with an intermediate sanction cell of probation, fines, and costs, even though the other statutes say that I shouldn't give it unless I think that you're not likely to reoffend. But I also don't think you're going to pay any money. It doesn't make any sense. You know what? No, I disagree. He's not going to pay. The court sentences, I'm going to take that off. I'm not going to sentence him to probation. The court sentences the defendant, and this is a violation. If the defendant wishes to choose to withdraw his plea, he can do so, because I know there's an agreement that there won't be any initial or upfront jail. I'll tell you, putting on that comment, I just didn't want to. Oh, by the way, and the fact that you were AWOL from the military, and then you were discharged, looks like an abstention with another than honorable discharge. The court sentences the defendant to a period of jail of 300 days. That's 100 days for each of the children involved. This applies to both counts 1 and 2, which will run concurrent. The defendant receives 97 days of credit. You two $68 state minimum fees, $130 crime victims' right fund fee, a $300 court cost, no fine. I'm just going to do actually, I'm going to strike that minimum court, a $100 court cost, a $300 attorney fee, no supervision fees. Do we have to do a DNA fee here, Miss Simmons? Lindsay?
Yep, I heard you, Your Honor. I'm just thinking.
should be-
I am not aware of
Let's
that.
take a quick look. He had some priors, but they were, well, he had an operator while intoxicated in 2007, but the rest of his felonies were in Texas.
That is correct, Your Honor.
So I'm going to say that there should be a $60 DNA fee payable to the Wexford County Sheriff Department. And Madam Clerk, if I need to fill that out, fill out a DNA order, please have one provided to me. All right.
Your Honor, anything with extradition?
Yeah, what was the cost for that? Court also assesses, of course, he's got to continue making his child support payments, and then the arrears again are $27,176.58. Plus, the court will also add restitution for extradition, which costs how much?
$4,817.
$4,817 payable to Michigan, to the state of Michigan.
Thank you, Your Honor.
This is one of those files where I don't know what good it does or doesn't do to put them on probation. Or, yeah, so, all right, anything that I missed, Miss Williams?
Could you repeat how much the crime victims fee is, Your Honor?
Crime victims fee is $130. There are two $68 state minimum fees, a $60 DNA fee payable to Wexford County Sheriff Department, restitution to the state of Michigan of $4,817, 300 days of jail with 97 days of credit as to both counts.
Thank you.
Thank you very
Nothing
much.
further.
Ms. Firavento, anything further on behalf of the defendant? And the next question is does the defendant choose to withdraw his plea pursuant to the, hold on. Was it a-
I don't think there was.
No, it was not. It was, you would just agree to recommend, Ms. Williams agreed to recommend what Sharon did, so therefore there is no right to withdraw the plea. Anything else, Ms. Firavento?
No, Your Honor, I did ask my client if he looked to the restitution hearing. He does not. Thank you.
Thank you. All right, Mr. Perkins, Mr. Bento's bringing to you 2 copies of one document. You're going to place your initials on it. Doing so neither elects nor waives in your rights. It merely acknowledges your receipt of the other copy. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. Any appeal will be by filing an application for leave to appeal if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you. You may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Do you understand?
For the record, Your Honor, my client is working on giving initials. He's
Yeah.
struggling a bit due to the handcuffs.
All right, thank you. Again, the court finds reasonable grounds based upon the factors already stated on the record. I will note that it does exceed the guidelines just briefly, but again, I find that there are substantial compelling reasons based upon the fact that he hasn't paid the amount, everything else. Thank you very much.
Thank you, Your Honor. Briefly for the record, I've given my client a copy of the notice of right to appeal, and he will take his copy back to the jail with him.
Thank you very much. We are adjourned.